This is the American Law Journal.
It's rare to see a workers' compensation case go before any Supreme Court, but that's exactly what's happening in the state of Pennsylvania. How will that impact you if you own a business or if you get injured at work? Good evening, I'm Christopher Naughton, and tonight we'll take a look at some of these celebrated cases now before the Pennsylvania Supreme Court. And also, does age really matter if you file a work injury claim? We'll tackle that, take your phone calls as well. But first, workers' compensation is nearing its 100th birthday, and some things simply don't change. Our producer, Valerie Jones, has this.
In 1911, Wisconsin was the first state to adopt a workmen's compensation law. Conflicts arose between organized labor and business over the no-fault clause, which compromised the workers' right to sue.
Workers' compensation is nearly 100 years old in our country, and for the most part, it's worked for American business and the American workforce. But the same old battles between employer and the employee are still being fought. Businesses complain of workers' comp fraud.
They say Dalton was willing to do anything to stay home from his job as a prison guard and keep collecting workers' comp.
Desperate workers can be very imaginative when they smell workers' comp money.
That, plus the high costs of workers' comp care, cut into profit.
For every dollar the insurance company spends on an injured worker, whether it's for medical care or disability payments, it costs you, the employer, $6 over a 4-year period.
But employee advocates say employers and business-friendly state legislatures are hurting injured workers.
Workers' compensation is the only remedy for an injured worker. An injured worker cannot sue their employer. In the state of North Carolina, the legislative body is trying to severely change workers' compensation law.
Workers' comp basically is no trial by jury, no court suit. It's all by an agency. So much for a hand, so much for a leg. It's called the chop shop. The laws are weak. They have to be reformed. They have been weakened in state after state over the last 20 years by legislation.
And the battle in PA is no different. Almost a half dozen comp cases have gone to the Pennsylvania Supreme Court in this year alone. Questions dealing with an aging workforce and voluntary retirement that ends comp benefits, to matters of public policy that sound as if they could have been written a century ago. Can an employee sign away their rights to a work injury claim as a condition of their employment? All of which reinforces the notion that even 100 years later, the map for workers' compensation is still being drawn. For the American Law Journal, I'm Valerie Jones.
And to a good degree, my four guests tonight have helped shape that workers' compensation map in the state of Pennsylvania. Let's go ahead and meet them. George Martin joins us tonight with Martin Banks. George and his firm, one of the longest standing workers' compensation practices in the state of Pennsylvania, representing claimants now for over 40 years. Paul Fires has joined us. He just got back from his trip so he could get back to the program. We appreciate that. With Weber, Gallagher, Simpson, Stapleton, Fires, and Newby. 9 offices throughout the U.S. representing insurance carriers and self-insured corporations in comp matters. George Beatty hails from Beatty, Sloan, and Geneva in Center City, Philadelphia. And George actually argued before the Pennsylvania Supreme Court just a couple of weeks ago, although not on a comp matter. It was a jury matter. George has represented injured plaintiffs in product liability, medical malpractice, and workers' comp now for over 30 years. And the Honorable Jeffrey DeLynn joins us once again, a workers' compensation judge, and before he sat on the bench, he practiced in this area of the law. Folks, we're taking your telephone calls tonight, 1-800-426-4625. There it is up on the screen. You'll see it throughout the program. You can also email your questions in, info@lawjournaltv.com. Let's take a quick look at some of these cases that are now coming up before the Pennsylvania Supreme Court. Actually, they've already been argued, nearly a half dozen cases. You heard that earlier in the news feature report. Some of the issues refraining from an injury claim as a condition of your employment, to employers modifying an employee's benefits, to what constitutes retirement and withdrawal from the workforce. But let's start with the bigger picture. 6 cases, 6 workers' comp cases in front of the Supreme Court. Is this a coincidence? Why so many cases at one time?
It's an important issue. It affects a lot of injured workers, and it affects employers. So there are understandably a lot of cases that are going to go to the Supreme Court because it's an issue that affects a lot of money
and a lot of people. So it's not so surprising that the Supreme Court is taking this many cases.
Paul Fiers, let's go to the respondents' counsel, as we call them in workers' compensation, also defense counsel. Do you see it the same way?
I do see it the same way. There are so many workers in Pennsylvania. Typically, 1/3 of the Commonwealth Court's caseload consists of workers' compensation cases. So naturally, when you look at that kind of statistic, a good percentage of them will probably make their way to the Supreme Court. Now, the Supreme Court has the discretion to take what it wants, but they are issues that affect Pennsylvania employers, Pennsylvania manufacturing, Pennsylvania unions, Pennsylvania workers. They're all critical issues, and unbelievable amounts of money are at stake in these cases.
Interesting. Now, George Beatty, these cases are often duked out in the legislature politically, but what it's telling me is that some things have not been settled in the legislature, so now judges have to get in there and interpret the law.
There's frequently ambiguity, and traditionally the workers' compensation law has been hailed as a humanitarian and remedial piece of legislation that's supposed to help injured workers. And more recently, we've seen punitive legislation come across from Republican-controlled legislatures that go against unions, against workers, and favor business. And hopefully the Supreme Court sees fit to pull us back toward the middle again.
Bowman versus Sunoco is one of these cases, and I'd love to be able to tackle this. And we're going to actually take a look at this case. And again, if you're a worker, if you're an employee, listen up, because if you do get injured, you'll thank us later for making this clear. I know it's a little bit esoteric, but before we talk about this case, let me go to plaintiff's counsel, claimant's counsel first. Why is it if I get injured on the job, I want to try to get outside the workers' compensation system? I really want to try to go after a third party. Why do I want to file a personal injury claim instead of a workers' comp claim if I can?
You're not limited to, under the workers' compensation system, you can only get your wage loss benefits and your medical benefits, essentially. You're not able to get pain and suffering and future damages and all those kinds of things that a jury would award for the loss of life's pleasures. So when you see those cases that go for $1 million or more, they're not workers' compensation cases. They're cases where a jury is deciding what your damages are. And in those cases, you have to prove responsibility or negligence on the part of a third party. You can't sue your employer. There was a trade-off. I'm sure George will explain the whole trade-off system almost 100 years ago. You give up your right to sue your employer, but you don't have to prove that they were negligent in order to recover your benefits.
Yeah. And the bottom line, Chris, the reason you want to be able to have that third-party suit is so that you can recover for all your damages. Work comp's limited. You don't get any pain and suffering. You don't get any loss of life's pleasures.
And that's really what's at stake in this Bowman versus Sunoco case, which the Supreme Court just heard. Again, an agency, a corporation that was a security agency, hired a woman and basically said, you can work here if you'd like, but if you work here, you can't sue one of our clients. So one of their clients was Sunoco, and obviously a security guard agency is going to send their employees to various premises, and they said, if you want to work for us, you can go over and work at Sunoco when we send you over there, but if anything happens over there, you can't sue Sunoco. So what's the problem with that, George Martin? We're going to get to Paul Fiers and the judge in a moment. But what's the problem with that? I mean, I'm an able-bodied individual. I have intelligence. If I want to waive my rights to sue my boss's client, why shouldn't I be able to do that?
Well, for one thing, Chris, you can't waive your right to workers' compensation. When someone hires you, they can't say, I'm going to hire you, but you have to agree that you'll never file a workers' compensation claim.
But that's not what this is. This case is about a third-party claim.
It's a third-party claim.
Gotcha.
But it's the same idea. And why should an injured worker have to give up their right to the third-party claim?
I think the issue is a public policy.
Yeah, Paul, let's go ahead, Paul. Let's get defense in there to get a comment or two in there. What's the problem here? Why should people not be able to file a lawsuit? Why should they have to give up that right to file a lawsuit against another company as a condition of employment? Isn't there something patently unfair about that?
There really isn't, because imagine if you're an employer, and for everyone out there who has a small business, do you really want your employees suing your clients? You'll go out of business. And that's a fundamental public policy issue that should be bargained for between the employer and the employee, keeping in mind one important thing. The trade-off that my colleagues mentioned. You will get your full workers' compensation benefits that you're entitled to. You'll get your wage loss benefits, you'll get your medical benefits, and you won't have to prove fault. Most of the cases don't involve lawyers. They're amicably dealt with between the worker and the insurance carrier. There's a thin slice of cases that do involve lawyers and do involve litigation, but most employees, when they're injured, are taken care of and their cases do get satisfactorily resolved.
All right, Paul, let's extrapolate that out just a bit further, though, okay? I own a business, and I've got a good working relationship with the corporation that produces my lathes and my forklifts and my jigsaws. And what if I say to my worker who wants to be under my employ, you can work for me, but if you get hurt on that forklift or that jigsaw, you cannot fire my buddy, you cannot fire my provider, we'll give you workers' compensation. Isn't that a slippery slope, and aren't we headed that way with this case if the court finds for Sunoco or Allied Barton in this case?
Well, in this case, they specifically talked about not suing a client, which is very different from not suing a provider of a service, such as the organization that manufactured the forklift or something like that. I can certainly hear the argument coming that it is a slippery slope and it may go there, but that's not what this court has said. And that is the issue right now before the Supreme Court. We don't know what they'll say. I have a feeling that they will endorse the concept that you can bargain away the right to sue a client of your employer in exchange for having the job. This is something that's not really complicated to understand, and I think most people and most of your viewers would understand. Most employers wouldn't want their clients, the lifeblood of their business, sued when they already get everything they're entitled to under the workers' compensation statute.
I disagree with that. I disagree totally. I mean, first of all, Paul used the word bargain for. It's not bargain for, not at all, not even close. You have a person coming in, an employee, a security guard, and they say, if you want to work here, you got to sign this. That's called a contract of adhesion. It means the employee has no bargaining power, number one. Number two, it's not just preventing them from suing. What it actually does is it insulates that third party from their own wrongdoing. So it gives them no incentive to be careful, to take steps to protect the people that are working there. It's rewarding them for their carelessness, in effect. So I think this is a horrible public policy that encourages third parties to disregard the rights and safety of workers because they can't be sued. So if somebody's supposed to keep a safe premises, why bother if you can't get sued?
But you will get sued. You'll get sued in workers' compensation by any other Sunoco employee who happened to have had the same unfortunate situation that the Bowman worker did. So there is, all of that protection is there. All we're saying in this case is you can't sue your employer's client, which I think anyone would understand.
It's hugely different. Your employer's client could be responsible for the pain and suffering, for the future pain and suffering, for the loss of life's pleasures, for the future medical expenses and future wage losses. All those things. The spouse of the employee can also sue. Under workers' compensation law, all those areas are foreclosed. You only get a limited amount of wage benefits and your medical bills paid. That's it. So you're giving up all these huge common law rights that you would have because you are forced to sign this agreement. And worst of all, you are rewarding a wrongdoer, someone who would be responsible for their actions.
Let Paul get a response, and then we'll go to George Martin.
Sure.
And Judge, I promise we'll get to you in just a moment. Go ahead, Paul.
Well, the part that's not been discussed is that even if you have the right to sue and even if you win, workers' compensation stops because you can only singly recover if you're an injured worker in Pennsylvania. Even if you get a recovery from a third party, whether it's a client of your employer or not, and we'll see what the Supreme Court says, but if you get that recovery, you're not going to get that recovery and workers' compensation benefits. There's a credit, so you can't collect both anyway.
I'm fine with that.
Paul, the fact that the Supreme Court took this case on appeal, I think, is a very good sign, and hopefully they will reverse the Commonwealth Court's decision on this. And the bottom line is, if you've been injured as a result of someone's negligence, you should be able to recover for your full damages, not what workers' comp provides.
And Judge, let me go to you. And although George Martin has just mentioned it, both the trial court, the Commonwealth Court, and the Superior Court, the appellate court in Pennsylvania, both found for the employer here. So does that give us any insight as to what may happen? You're going to say no, of course.
Well, I think George Martin makes a good point that the fact that the Supreme Court took the case shows that they're very interested in the result. Another issue that you need to think about is the Superior Court, when they decided the case, said basically the injured person is getting all that they're entitled to by virtue of workers' compensation. But as the two plaintiffs' lawyers on the panel pointed out, that's not really true. They're giving up their common law right to pain and suffering damages, the wife or spouse's damages, future damages, lost earning capacity. So they're really not being recompensed for all of their loss. And I think that's what might have intrigued the Supreme Court.
There are two cases also that talked about these issues that were mentioned by the Superior Court. There's an Arkansas case that said, yeah, it's okay to sign such a thing. So Arkansas agrees with the defense on this. But then there was a case in Connecticut in 2006 called Brown versus So. And in the Brown case, the Connecticut Supreme Court said, no, no, no. This is a contract of adhesion. An employee has no bargaining position in such a situation.
So Pennsylvania will have to make up its mind on its own, ultimately, with the Supreme Court. Let's go to a bevy of other cases, all stemming from the city of Pittsburgh. And again, I'm not going to get into the detail, but it's interesting because we're talking about age tonight and at work injury and how being young or old may factor into you filing and receiving workers' compensation. At least 3 cases deal with the whole notion of voluntary retirement, disability pension, a little bit of an age issue tinge to these cases.
Age is critical in workers' compensation. It makes a huge difference in these cases. And what the Commonwealth Court has done in a whole series of cases is to make new law. It's been an activist, conservative court which is making new law. The legislature in 1996 set forth what happens when someone retires. When you retire and you take your Social Security retirement benefits, you lose 1/2 of what you receive in Social Security retirement. That's what the legislature decided. The Commonwealth Court has taken that much, much further and said that when you withdraw from the workforce by taking your Social Security retirement and by taking a disability pension because you're disabled as a result of your work injury, that you lose everything.
Judge, it must be making it a little tough on you to figure out, has this person retired from the workforce or not?
Well, as George pointed out, there have been a line of cases, and the newest standard that we as judges have to look at is under the totality of the circumstances, the facts of the case, has this person really taken themselves out of the labor pool such that the employer has no obligation to offer them work and try to reduce their benefits. Basically, the courts are saying if the person's not working, they shouldn't be entitled to wage replacement if they have no intention of returning to work.
And actually, we have an email from someone joining us right now. We're actually writing in, Stephen, from Bethlehem, Pennsylvania. Could your guests explain for me why it's not double dipping for a worker to be paid for disability pensions and still be able to collect temporary workers' compensation payments? Let me throw that over to Paul Fiers.
It is double dipping, isn't it? I think
you might say that.
Yeah, I think the gentleman makes a very strong point, and I think it's something that most people will understand, and hopefully the Supreme Court will understand that as well. If you've removed yourself from the workforce and you're not actively intending to or seeking work in the future, if you've decided to retire, what logical entitlement do you have to what's called wage replacement benefits? That's what they're called. They're sometimes called indemnity benefits, but they're also called, in common parlance, wage replacement benefits. If you no longer are seeking a wage, there's nothing to replace. And that's evidenced by getting a disability pension.
But Paul, the reason these people are taking their disability pensions is because they were injured on the job and they're disabled. That's why they're taking their disability pensions. Not because they're trying to retire. And as far as collecting their disability pension, that's something that they've paid into through the years. That's a contract right that they've earned, and they've most likely paid at least as much as their employer into that fund. So they're just getting their own money back under the terms of the contract of the employment that they've had for 20, maybe 30 years.
But I don't think it's always that simple, because sometimes the majority of the money, if not all of the money, does come from the employer, number one. Number two, sometimes when people hit a certain age, they are maybe retiring because of a work injury, they may be retiring because of other disabilities, they may be retiring for other reasons, they may just have decided that they no longer wish to work. Now, I certainly agree that if you have a pension, you have every entitlement to it. The question, I think, for most people who are thinking about this, and your writer included, is why should you be able to get both if you no longer have wages that need replacing? I think that's a very basic, common, fundamental concept.
Well, you know, to respond also, to the caller or the email person saying, is it double dipping? What about a person who was making $2,000, $3,000 a week and is very limited? Comp has limits on it. You can only get $800 some a week if you were hurt in 2012. That's the maximum you could get. So in a situation where a person was earning much more, they're limited under workers' comp. So why shouldn't they be allowed to get the, it's not even double dipping, not even under Paul's definition, if they got a disability pension also.
And you can get Social Security disability benefits and workers' comp benefits. I know it's different than a disability pension.
There's a credit. Social Security disability would get a credit.
Okay.
Partial
And you
credit.
need to distinguish Social Security disability from Social Security retirement.
Right, of course. Let's switch to the age issue, because as the baby boomers now move through the system, we are the pig or the cow moving through the snake, however you'd like to, whatever metaphor you'd like to use. Judge, when you deal with an issue, when age is a primary factor in a workers' compensation case, how does it change the playing field?
Age is a level of complexity for a number of reasons. If the injured worker is terribly injured and they're of an older age, then getting them back into the workforce or having Mr. Fire's clients prove that they can return to work in some capacity is obviously more difficult. Whereas with the younger injured worker, it's more likely that unless the injury is really horrible, that the time is working against them and in Mr. Fire's client's favor.
And what do you tell someone who walks into your office, George, that is 50 some odd years old and they're facing what could be, a very debilitating injury? Now, doesn't your entire strategy change as you approach the matter?
All the strategies change when you're dealing with the older individuals, because the first thing you want to look at is whether or not they should also be filing for Social Security disability. It's hard to get a younger individual onto Social Security disability because, as the judge pointed out, younger people usually can be retrained, hired to do something different. Whereas older individuals, they're less likely to be retrained. It's a lot harder for them to get employment. So you're looking at, can I get this person onto Social Security disability? If so, how can I maximize their benefits under both Social Security disability and work comp?
Gotcha.
Because there's an interplay between the two, and you need to weave your way through that system.
And that's a critical issue. I guess what I was thinking of, George Beatty, was, are there sometimes indices or suggestions or indications of maybe age discrimination where maybe this injury might be used against this person who is older, may break down more easily, has a higher salary, and maybe now the employer finds, okay, this might be a good time to get rid of this guy.
That's not usually what we find in these workers' comp settings, because the person's already out of work and getting benefits when they come to George or me. But the situation, workers' compensation is paid out. Social Security disability gets to take a credit. So if we settle the workers' comp case, for example, for a lump sum, how that's worked out is that's taken out and they calculate what would that equal over the lifetime of this employee, so that in most cases, if a person's getting Social Security disability and they settle their workers' comp case, their Social Security disability will go up in most cases.
We've got a lot to cover tonight, but I don't want to miss some of the phone calls and the emails we're getting, so let's get to those right now. Dolores, you're up first tonight. What's your question for our panel? Dolores, you're on the show. Go ahead.
Hello?
Yes, go ahead. You're on the air. Go ahead, Dolores.
Oh, hello. My daughter, she had a hockey injury, and she was in a lot of pain, and she wanted to have surgery on her hip. Her femur. She tore her femur, and there was already a person out at work. So they told her she couldn't go get her hip fixed. She had to work until this other person came back. So they told her to go get crutches. And then she went outside to euthanize a dog in a car with the physician. And when she came back in, I guess the floor was wet because it was raining, and her crutches went down underneath her, and she fell and she did a split, and she tore her just a slight tear, but she was in quite a deal of pain.
Let's go back for a minute. No, hold on just a moment, Dolores. You said she was playing hockey. She's not a professional hockey player.
She's on the Women's World Hockey League.
Okay, so she's employed as a hockey player.
Yes. Okay. No. She's not employed as a hockey player.
Okay.
It was her sport. It's her hobby.
Okay.
I think you're talking about the aggravation of the injury that happened at work.
Right.
I think that's what we're getting to here.
Gotcha.
Yeah.
Was that what we're talking about? That she was.
Yeah. Now we're talking about when she fell because they told her she had to work anyway with the injury. And then they told her to get crutches to get around, and then she fell. And then they told, then she went to the doctors, and they moved the surgery up. She had to wait till the other woman came back before she could have her surgery, but they moved it up because now she's in a great deal of pain.
That's something
and
that
they didn't want to pay her.
That's something that, workers' compensation covers injuries even if the injury aggravates a pre-existing condition. So the work injury part of it doesn't have to be the only thing. The work injury could aggravate a pre-existing condition, which is the situation here. So that is likely a compensable injury that she suffered at work if it made her original injury worse or accelerated it.
George and I are going to agree that's a compensable injury, and I suspect Paul's going to disagree, and the judge will figure it out.
Paul, go ahead, Paul.
Well, I actually think it does sound like it could be a compensable injury, but the one part that wasn't discussed, which needs to be mentioned to the caller, is this. She will come to the injury with whatever her pre-existing condition was. So what workers' compensation could be responsible for here is the extent of the aggravation. And ultimately where the responsibility may end will be when the aggravation is returned to whatever baseline condition that she had.
Let's get to some emails as well. We're going to try to get them in, and actually we're going to stay a little longer in the studio tonight, even once we leave the air at 7:30. Keep calling in with your questions, and you send your emails to us. We'll try to get to them off the air after we're finished. This is from Manuel in Newton, and this is, yes, thank you, graphic number 2. I recently suffered a shoulder injury on my job working on a loading dock. I was told that I could be fired from my job if I reported the injury to my supervisor because my employer is enrolled in the Pennsylvania DOLE program, Workplace Safety Program. I don't know what that means. You guys will help me out. I need my job and cannot afford to miss any work. What should I do?
If you get fired because you reported a work injury, you've got not only your work comp claim, you've also got a third-party claim against your employer for firing you.
Okay.
You can't be fired for reporting a work injury.
Gotcha. Andy, you want to take one more? Do we have enough time for another call? All right, we need to wrap it up, but we're going to continue taking your telephone calls and your email questions, at least for the next 15 minutes. Off the air, I want to thank my guests. It went by quicker than I even expected to go by.
Chris.
George Martin with Martin Banks in Center City, Philadelphia, joining us tonight, claimants attorney now, 4 decades plus for Martin Banks. Paul Fiers, joining us once again with Weber Gallagher, Simpson, Stapleton, Fiers, and Newby, representing the respondents, or representing the carriers and the self-insured corporations. George Beatty with Beatty, Sloan, and DeGeneva, zealously representing claimants for about 3 decades. And the Honorable Jeffrey Dillon. Thank you for joining us, Judge.
Thank you.
And for all of us here at the American Law Journal, thanks for joining us this Monday night. Until next Monday night, case closed.
This week's American Law Journal has been made possible in part by Martin Banks. We wrote the book on workers' comp law. Beatty, Sloan, and DeGeneva. Personal attention for those hurt at work or suffering from serious injury. Weber Gallagher, representing business, financial institutions, and the insurance industry worldwide. And the Legal Intelligencer, the nation's oldest legal newspaper for lawyers.